Good morning, everybody. My name's Jack Harrison. I'm a family lawyer at Coram Chambers in London and at Dean's Court Chambers in Manchester. I'm going to attempt to put a PowerPoint on, which may or may not work, so just bear with me. But the short sort of talk I want to do this morning is to try and answer the question, where are we going in the family court? Where are we going in terms of how the family court deals with cases of domestic abuse? And I want to do that really with reference to three really significant legal developments in the last year. The first, as Nicola said, and really the topic of this panel discussion is the harm report. The second is the Domestic Abuse Act of 2021. And the third is the case of Re-HN, which, as I will discuss, is probably the most significant Court of Appeal decision in this area of law for about 20 years. So I'm hoping that you will be able to see my screen. Can you all see that?
Yes, we can.
Great. So where are we going? Well, the first thing to say is that the approach of the family court to cases of domestic abuse was set down a few years ago now in Practice Direction 12J. That's something that you've probably heard quite a lot about if you work day to day in the family court. And that was really the first time that a full spectrum definition of domestic abuse was incorporated into some kind of law. And that marks a departure from the terminology that used to be used in cases, domestic violence, people being physically violent in ways you can see, sort of to a new approach where all the different types of domestic abuse were recognized as harmful. So we're talking about coercive and controlling behavior, financial control, the various ways that perpetrators have to cause emotional abuse and emotional distress. And this really was the first time that such a wide definition of domestic abuse was incorporated into law. It contains the understanding, or contains the message that domestic abuse is harmful to children, both if they are subjected to it and they are witness to it. And of course, that is likely to impact, or the presence of domestic abuse is likely to impact on the parenting capacity of the child's carers. The approach that the court should take was laid down, which is where there are allegations that really relate to the question of risk. Is it risky to make this decision or to give this child contact or whatever? If there are allegations that go to that question of risk, then the court should hold the finding of fact hearing and should have an inquiry really into those allegations. Now, I hope you can see that that's moving. That's from the Crystal Maze. And that's kind of how I feel about the family court at the moment and domestic abuse. Family justice professionals are wearing brightly coloured jackets, whilst the world around them is completely uncertain. There are tickets flying everywhere, the wind making it impossible to see. And that's because we're at the stage of reform where we know what the problems are, because the harm report has told us that. And that's based on an expansive body of empirical evidence and research. But we don't necessarily know how that translates into reform. So there is the Domestic Abuse Act, but that's in the early days. There's Court of Appeal decisions that mark a sea change. But again, we're very much in the early stages of reform. So to say we're in the Crystal Maze, we know roughly from Practice Direction 12J what the approach of the family court should be, but there's a lot we don't know. And there's a lot of confusion, I think, with professionals, legal professionals and judiciary as to the approach that they should be taking in cases of domestic abuse. The harm report, well, that exposed widespread concern really about the family justice system and the way that it deals with allegations of domestic abuse and the way it protects people who come to the family court making those allegations. It's fair to say that when the spotlight review or the panel was put together to produce this report, they did not expect to receive the volume of contributions and responses that they got. They had over 1,200 responses from individuals and from organisations about their experience of the family court. And that's a really good thing because it means that its recommendations are well considered and drawn from a large base of evidence. The three headline findings were firstly that litigants and people who go to court felt that their abuse was being systematically minimized or ignored by judges, by lawyers, by professionals, CAFCAS. Secondly, that they found the process to be traumatic. And in some cases, many of the respondents said that the proceedings had become a form of abuse in themselves. And thirdly, that the assessment of risk by professionals in cases of domestic abuse is inadequate and quite often inadequate. Now, those are three pretty big findings. And certainly I was surprised to read it, and I was horrified, quite frankly. There's been a level of professional defensiveness, I think, about this report. And there's lots of people, lawyers, judges, professionals, who feel that the harm report is not sort of concordant with their experience, that it doesn't match up. And actually, I think that's the wrong approach, because this is a report that says some really serious things that should concern us all as professionals working in the family justice system. And it's based on, as I say, a broad body of evidence. I think that these recommendations or that these findings will probably form the basis of any reform that we see from here on in the family court system. These findings will be at the foundation. So it's a hugely important report and hugely important observations. Why is the system like it is? Well, the panel found 4 reasons. Firstly, that the resources available were just inadequate. There was a caseload. I'm sure everyone in the room will be aware. Private law cases are going up just a little, but they have doubled, if not quadrupled, certainly from the early 2010s in terms of the number of private law applications being issued. And you only have to go on CAFCAS website to chart that very concerning trajectory. More people are coming to the door of the court earlier and earlier, and more people are litigants in person. And that requires a greater amount of judicial resources, both in terms of hearing that number of applications, but also in the time that each of the applications take. What might have taken half an hour with lawyers on each side now takes 3 hours to deal with litigants in person and to make sure that they are able to engage properly in the process. Secondly was a pro-contact culture. Now, that was their words, but the panel thought on the evidence that the pro-contact culture and the priority of some judges in re-establishing contact caused them and caused professionals to minimise allegations of domestic abuse where they existed. Thirdly, what they called working in silos, everyone working in their own little boxes, but with no joined up thinking. The criminal justice system doesn't talk to social care, who don't talk to CAFCAS, who don't talk to the lawyers, who don't tell the judges. And that means that the system can be confused, and that the different agencies, as they're involved, adopt different approaches. So you might end up with sort of contradictory decision making. What a court might consider acceptable might not be considered acceptable by children's social care. So there's different standards being applied. And fourth and finally, the adversarial family justice system, sort of pitting parents against each other in the way that happens, it is really problematic. So there were some recommendations from that. Whether they or how quickly they are implemented remains to be seen. The main one, from an architectural point of view, was that the family justice system should have some design principles, a sort of practice statement that guides future reform and that guides practice. And that really related to the development of a culture that recognised trauma and recognised the profound effect that domestic abuse can have on families and on parents. The private law working group have said, well, that's a group set up by the president of the family division to look at how the family justice system can deal better with private law applications, have sort of said, well, let's wait and see. They had done quite a big report that talked about a lot of things, talked about mediation, talked about tracking cases to deal with them efficiently, but didn't talk about how cases of domestic abuse can be dealt with because it was outside of their remit. But they're now going to look at this. So as I say, we're still in the crystal maze. Watch this space. This is the foundation of what's to come, and I'm certainly very interested to see how the private law working group deal with the findings of the report. The second is the Domestic Abuse Act. Now, it's finally an act. It was a bill introduced in 2017, and I think they had about 4 attempts to get it through Parliament, which, well, that may be a reflection on the importance placed on this issue. But there were about, I think, 3 or 4 attempts. The first involved a session of Parliament that was ended when Theresa May went on a walking holiday, looking very pleased with herself. Then Brexit, that ruined everything for years, in fact, didn't it, through Parliament. Coronavirus, that sort of has caused no end of disruption to Parliament being able to deal with legislation. And so it only found its way into law in the spring of this year. Now, this statute contains effectively the same definition as Practice Direction 12J of domestic abuse. So there is now in law, and it's in force, it came in force 2 weeks ago, a full spectrum legal definition of what domestic abuse is. It's not just violence, it's emotional abuse, coercive and controlling behavior, financial abuse, all the different components that make up the enlightened understanding of domestic abuse we have now found their way into law. And there are a couple of really important things in terms of the courts that this contains. One of them we've already got mainly, which is special measures. That is the recognition that to give their best evidence, people who are making allegations of domestic abuse should be entitled and should have the benefit of special measures, screens, giving evidence over video links, pre-recording their evidence sometimes, a whole range of things that can be put in place. For you as professionals in the family justice system, you absolutely need to be aware of these options, because the court may be saying to you, particularly if there's litigants in person, when you turn up at a FEDRA, okay, well, what does this case require? And so it's important to have an awareness of that. The next important thing relates to cross-examination. I'm going to adopt some shorthand now, but quite often one will see in cases involving allegations of domestic abuse that one party who alleges abuse has legal aid and the other, who is on the receiving end of the allegation, the alleged abuser, doesn't. And that means that the alleged abuser has to cross-examine the abused, which is a hugely problematic thing. And actually, there was a Women's Aid report in 2016, a really wonderful report, and if you haven't read it, you should, which said this: allowing a perpetrator of domestic abuse who's controlling, bullying, and intimidating to question their victim when in the family court regarding child arrangements orders is a clear disregard for the impact of domestic abuse, and often perpetrators of abuse, and often gives perpetrators of abuse an opportunity to wield power and control. Now, that was 5 years ago that I think very obvious statement, but very profound statement was made. It is still not the case that the court, as it can in crime, as those of you who have experience of crime will know, can appoint a lawyer to cross-examine. So at the moment, we sort of have to make do. What will normally happen is that the judge will ask the abuser, if I can use that shorthand, to write down the questions they would ask, and the judge will ask them. Puts the judge in a very difficult position, and it's uncomfortable for anyone who's ever had to witness that happening, as I have on a number of occasions. But the court at the moment is powerless really to do anything about that. In the spring of 2022, we are told that that will change, and the court will have the power, because of this act, to appoint lawyers for the purpose of cross-examination. At the moment, we don't have that. All we have is what the courts called the forensic life craft, which in effect means appointing a 16-4 guardian and getting them to do all the lifting in respect of that. That again, as many of you will know, having been probably involved in those cases, puts the guardian in a difficult position as well. So this is a really, really important provision. It will completely, I think, change the way courts deal with these sorts of cases, but it's not enforced yet. The last important legal development is what we call close the door orders, orders under section 9114. They're orders, as you probably know already, that stop or that will stop a party applying to court in a certain time. So at the end of difficult proceedings, if you've got a parent who's making applications over and over again, the court can say, well, look, give it a rest for a year. You're not allowed to make any further applications unless it's urgent, and we'll make an order to stop that parent doing it. This act creates another gateway for those orders, because at the moment, you can only really make those orders if someone is being a pest. So if someone is making repeat applications or making really spurious applications, the court has the power to stop them. This act gives the court, although it's not in force yet, it must be said, the power to make these orders where a further application would put someone, a child or a parent, at a risk of harm. So I can see this being a particularly useful and important tool that courts will have to employ and that professionals will have to recommend if proceedings are becoming or have become abusive. So that is something to be aware of as well. There is, this isn't coming into force until I think spring 2023. We know absolutely nothing about these orders at the moment, but the Domestic Abuse Protection Order has formed part of the Domestic Abuse Act. We think, although we don't know, that they're pretty much like non-molestation orders. So it's a form of injunction that the family court can make. The difference between these orders and non-molestation orders, as far as I can see, is that they can be mandatory as well as prohibitory. And by that, I mean they can make someone do something as opposed to just stop them going 100 meters from the house. Now, this might be used, again, by you as professionals to say, well, actually, this parent needs to go on a perpetrators course, or this parent needs to engage with some sort of service. The court, I think, although it needs clarification because it's a long way off, technically has the power to make that happen by making an injunction. Now, whether or not these will ever be implemented, I don't know. It seems to me that that is very problematic. As a power, it's a very, very strong power. And when you consider that the sentence is, or the breach, the potential for breach is a sentence of imprisonment, seems slightly strange that the court would say you have to go on a course or we'll send you to prison. The better thing to do would surely for the judge to say, well, you're not seeing your kids. So how they will be used, who knows at the moment, but please do be aware of these, because again, it's another tool in the armory of professionals, and they will, I imagine, be talked more and more about as we approach implementation. The final thing, and I'm looking at the time, I'm probably way over, so I apologise, is RE-HN, which is a really, really important Court of Appeal decision. This is about whether or not there should be finding of fact hearings and really how they should be conducted and with what allegations. The important takeaway points from this case, and I'll summarise them very quickly, I think, is firstly, the question of whether or not the allegations go to risk is always going to be the most important. So when a parent raises allegations of domestic abuse, how does that affect the risk analysis that the court will have to employ? If it does, then it's important, it has to be litigated, but you always have to look at that. And really, it's about the Scott schedule, the way that the courts deal with these cases at the moment. At the moment, one party will put a big list of allegations down. I've put an example here. Jack went to the pub on the 23rd of June. That's one allegation. The problem with that is that if you have lots of different allegations, you lose sight of the bigger picture, and it can sometimes distort the picture if you reduce a relationship and the experience of being in a relationship with someone down to a short list of allegations. The court have said this is the wrong approach. What you need to look at is the experience for that parent of being in a relationship with the other parent, and that's what the court should look at. So I am getting lots of raised hands, which I assume means that my time to speak has come to an end. That, in a nutshell, is where the courts are going. And obviously, I'll be happy to take any questions when we get to the panel event, but thank you very much for listening for now.
Thank you, Jack. I'm not sure if I'm on screen, but thank you very much, Jack. And now we're going to hear from Dr. Jenny Birchall. Thank you.
Thank you. Hello, everyone. Thank you for inviting me to speak today. As some of you might know, Women's Aid is the national charity working to end domestic abuse against women and children. We're a federation of over 170 organisations which provide just under 300 life-saving services locally to women and children across England. In 2016, we launched our Child First campaign, which calls on the government and all family court professionals and involved agencies to make the family court process safer for women and children survivors of domestic abuse. Our campaign was launched with our 19 child homicides report, which I think might have been the one that Jack referred to just then in his presentation. And this report detailed the deaths of 19 children and 2 women in 12 families who'd been killed in circumstances relating to child contact by a father who was a perpetrator of domestic abuse. So we've been running this campaign for 5 years now, and we've seen some really welcome changes and improvements in terms of policy and practice. Policy and guidance, I should say. But in practice, we're still seeing problems with the family court response to domestic abuse. And unsafe child contact remains one of the uppermost concerns of the survivors of domestic abuse that we work with. So we were really delighted when in 2019, the Ministry of Justice announced that an expert panel would be set up to assess the risk of harm to children and parents in private law children's cases. And as Jack mentioned, the panel was made up of experts, including academics, the judiciary, the legal profession, children's social work and domestic abuse sector organisations. Women's Aid was represented on the panel. So as Jack has just explained, the panel's work included a call for evidence, and it culminated in the publication of a report, what we now know of as the harm report. And Jack's been through some of the findings of the harm report, so I won't repeat that. But as he talked about, the panel identified these 4 overarching barriers that family courts are facing when they're trying to respond to domestic abuse and other serious offences of child harm. And the one that of those 4 barriers, which are all, of course, really important, the one that we have talked most about is the pro-contact culture. that we have seen it again and again as something that a barrier that survivors come up against. And I must say that while Jack mentioned that he was quite surprised or shocked at some of the findings of the harm panel, at Women's Aid we weren't surprised or shocked at all, because these were exactly the things that survivors have been telling us for over a decade, in fact. And actually we were relieved that the report highlighted these things and brought it into the public domain in the way that it did, and started off these conversations. So we were really glad to see the recommendations in the harm report, and particularly the recommendations around the redesign of procedures and of the child arrangements programme. Particularly, the report highlighted the need for a reformed child arrangements programme that is safety focused, trauma aware, takes a problem solving approach, and which really has the needs of children at the centre, and has central consideration to litigants in person and domestic abuse. So we were really pleased to see these recommendations. There were also important recommendations around, for example, IDFAs and domestic abuse advocates should be automatically allowed into court to accompany the party that they're supporting. And there was a recommendation around a wide range of training for all participants in the family justice system, and it talked about cultural change in order to introduce and embed reforms. It also talked about the need for a consistent and comprehensive method for gathering administrative data on cases, whereas at the moment we don't have any centralised data that we can draw on. So on the 25th of June this year, it was 1 year on since the publication of the harm report. So it was a good time to sort of stop and think about what's happened since. So during that year, we saw some welcome changes. So as Jack talked about, the Domestic Abuse Act brought new measures around cross-examination, special measures, barring orders, and also the new definition of domestic abuse specifically says that children are victims of domestic abuse in their own right. So that was a real step forward. At the same time, during this year, the MOJ, the Ministry of Justice, began some reviews. They're doing a review of the legal presumption of parental involvement. They're doing a review of domestic abuse perpetrator programmes. And there's also been some pilot work started around integrated domestic abuse courts. And this is running alongside some of that other private law reform work that Jack was talking about to trial new approaches. The Domestic Abuse Act also brought our new Domestic Abuse Commissioner. She has a new role, part of which includes monitoring cases and outcomes involving domestic abuse in private law proceedings. So that's something going forward that we hope will bring change. And at the same time, during that year, we know that CAFCAS has done a lot of work to develop its learning and improvement plan on domestic abuse in response to the harm panel's findings. And at Women's Aid, we've been really pleased to be involved in the development of that. As Jack mentioned, also during that year, we saw cases at the Court of Appeal. We saw 4 joined cases go to the Court of Appeal, all from mothers who'd experienced dismissive attitudes and minimisation of the domestic abuse and sexual violence they'd experienced. And 3 of those 4 appeals were upheld. And the judgment noted that the appeals demonstrated the importance of judges and magistrates having proper understanding of the nature of domestic abuse, and in particular of controlling and coercive behaviour and its impact on both victims and children. So while it was really positive that those joined appeals were allowed to go forward and that 3 of them were upheld, we want to note that the majority of survivors are not in a position to appeal. And this is such an important point, because Other than appealing, there are no clear routes to challenging poor decision making and lack of awareness around domestic abuse in the courts, so that there isn't really effective oversight or accountability. So 1 year on from the Harm Panel's report, we've seen some progress, definitely, but we've not seen the broader systemic changes to the family court response to domestic abuse that the Harm Panel recommended. At Women's Aid, we held an event in June to mark the 1 year anniversary, and we had a range of speakers there, including people who were on the Harm Panel, the Domestic Abuse Commissioner and the Family Justice Lead for Domestic Abuse. They all agreed that there's still much work to be done. And in the run-up to the event, we asked survivors of domestic abuse who'd been in the family courts during that last year to tell us about their experiences. And we asked them to complete the sentence. During the last year, my experience of the family courts has been. So here are a couple of examples of what they told us. One survivor said, absolute trauma, utter disbelief at how little they listen, how easily they can wreck lives, and most importantly and shockingly, how little they prioritise the voice of children and what is in their best interests. Another survivor said, it has been both positive and negative. The family court system has so many broken areas, but with dedicated and continued work by so many committed people and survivors, ensuring their voices are louder, we can all be stronger and challenge the family court dynamics. So we can see that from the point of view of survivors of domestic abuse and their children, there's still a lot of work to be done. So I'm going to finish with the words of another survivor who said, I want the courts to understand how life-changing it is and how devastating it is, not only to be abused yourself and then have your children abused, but then to go through such an awful process to try and keep your children safe. How frightening it is to have your child go off every week to someone who is capable of that. They've taken safety away from my child and I pray nothing will ever happen. So my message today would be that unless we listen to what the Harm Panel said about the need for a safety-focused, trauma-aware approach that has the needs of children at its heart and which is adequately resourced and linked up and held accountable for its actions, these failings will continue. And it would be such a shame to not build on all the work that is going on and not take it forward. So at Women's Aid, we're going to continue to lobby for full implementation of the Harm Panel's recommendations, and we hope that you will join us. Thank you for listening today.
Many thanks, Jenny, for that presentation. We are now going to move on to hear from Natalie Wyatt. Thank you very much.
Good afternoon. Hi, everybody. Hi, so my name is Natalie Wyatt, and I am a Senior Improvement Manager at CAFCAS. So I work for the team that has responsibility for kind of really driving practice improvement across the organisation. I'm from a social work background, so my focus is very much kind of on the day-to-day frontline practice. So as you all know, CAFCAS is an arm's length body of the Ministry of Justice, and we are responsible for representing the voices of children and young people who find themselves at the centre of family court proceedings. Of course, that is in both private law, where parents have separated, and in public law, where the state is intervening in order to keep a child or children safe. Just to kind of give a flavour of the current context, I guess, that our family court advisors are currently working in, and against which the Harm report was published. So we know that the number of open kind of active cases, the number of children with active cases known to CAFCAS at the minute really kind of remain close to record levels. Against a kind of a backdrop of backlogs in the family court kind of caused by the pandemic. And so although we know that demand in private law has kind of reached pre-pandemic levels. The number of cases that are concluding is 18% lower. So there's a real kind of backlog in terms of children and families who find themselves at the centre of these proceedings. I think the average case duration at the moment, so for children in public law cases, they will experience proceedings which are on average, I think, 44 weeks in duration. And for children at the centre of private law proceedings, those cases that go beyond the first hearing, that go beyond the FHDRA, we're looking at 53 weeks duration at the moment. So it's a tough climate, it's a tough environment out there. And of course, as we've heard in June last year, June 2020, the Ministry of Justice published the Harm Panel report, really exploring how effective the family courts are in terms of identifying and responding to allegations of domestic abuse. And as we've heard, helpfully summarised by Jack, there were a number of weaknesses and areas of learning in terms of the whole family justice system. So resource constraints, really kind of limiting the time that professionals are able to spend with children and families, including CAFCAS, that pro-contact culture, or that kind of contact at any cost approach that Jenny also helpfully touched on. Agencies working in silos, and of course that adversarial nature of the system, kind of pitting one parent against another, which is problematic in any context, but particularly so where there is an inherent kind of power imbalance between the parents. So I guess that kind of triggered a period of real soul searching, I would say, was my experience kind of internally at CAFCAS. It was like Jack described it, some elements of it were sort of difficult to hear. But I hope, you know, the sense I got from certainly from our frontline practice staff was that there was real determination to learn from the messages in the Harm Panel report. There has been a real appetite, I would say, or energy for really strengthening our practice and improving the work that we carry out with children and families who have experienced domestic abuse. So in order to really kind of drive forward that practice improvement and to help us get it right, CAFCAS set up a learning and improvement board. And so this learning and improvement board, it's chaired independently. So it's chaired by Kathy Ashley, who's Chief Executive of the Family Rights Group, and Angela Fraser-Wicks, who's also a trustee at the Family Rights Group and a founding member of their parents panel. And the wider kind of membership, the wider kind of board membership, they're actually meeting this morning as it happens, is made up of partners really from across the family justice system. So of course we're very grateful to Jenny and her colleagues for their participation on the board. We have, I think, magistrates and various legal colleagues in there. But of course, survivors, we have a number of experts by experience, people with lived experience of the family justice system, and of course, representation from the Family Justice Young People's Board as well. So a really diverse group of board members, including some of our own practice staff as well. So what's the plan? What steps are we taking as a consequence of the Learning and Improvement Board? So we in terms of kind of developing that plan, in addition to sort of hearing the voices of colleagues who sit on the Learning and Improvement Board, CAFCAS also carried out an audit of a sample of 200 cases, 200 children's records where domestic abuse was a feature. And we did case file reviews of those cases against some of those key lines of inquiries coming out of the harm panel report, so that we could really get a sense of what that practice looks like on the ground, and what we need to do better. As part of that process, we also did an external moderation exercise as well. So we took a selection of the cases from the audit, and we then examined those cases in a group that was chaired by Professor Eileen Munro, and again was made up of some volunteer members from the Learning and Improvement Board. So they were kind of scrutinising the work of the auditor, if that makes sense. So they were give us some helpful challenge around, well, are we measuring the right things? Is our feedback that we're giving as managers and practice leaders, are we giving the right messages? Are we encouraging practice that is trauma sensitive, that prioritises safety and doesn't reinforce this kind of pro-contact culture? So really valuable exercise. We will be repeating, we're in the process of repeating that large scale audit again, sort of a year down the line, and I expect we'll probably do it another year again down the line, just so we can really track the impact of some of the changes that we are attempting to make at CAFCAS. And also there have been a number of focus groups that helped inform the Learning and Improvement Plan. So again, the Family Justice Young People's Board, there was a focus group with Women's Aid and Match Mothers, a session with Families Need Fathers, and a session with some of our own family court advisors. So through those channels, we then drafted the Learning and Improvement Plan. And this kind of has 4 pillars. So the first one is really around ensuring effective management oversight. So it's really important that any practice improvement isn't just kind of laid at the feet of FCAs. It's not just the responsibility of frontline staff. It's about how do we as managers, as practice leaders, really support best practice, and how do we challenge some of the potentially unsafe court orders that we sometimes come across. I know from my own experience of working on the front line and being close to practitioners is that it can be frustrating when you yourself have made quite robust, safe recommendations, but perhaps the court doesn't always adopt those recommendations. So we've now sort of woven into policy and in some of our training material an expectation that managers really support practitioners in challenging some of those potentially unsafe court orders in perhaps a more systematic way, and a slightly more robust way than we have done historically. We're also developing personal learning plans for all of our practice staff. So again, that is pretty much everyone who holds a social work registration in CAFCAS, not just our frontline practitioners, but myself, my colleagues in NIS, colleagues in senior leadership, etc. And that will be measured quarterly through our kind of routine practice learning reviews. Then the second pillar of the plan, and this is the pillar that I kind of work closest to in terms of my role, but is really around strengthening practice. So really, like Jenny described, you can put in place all the policies, all the processes, all the procedures that you like, but without really ensuring that they connect at ground level and that they are being adopted in practice, then that they're not likely to have impact. So to really assist our practitioners with some of their the day-to-day practice, we've really updated, refreshed and relaunched the CAFCAS Domestic Abuse Practice Pathway. That was a piece of practice guidance. It was first introduced in 2016. We knew that was ready to be updated in any event, so some of this work actually slightly kind of predated the harm panel report, but the harm panel report certainly galvanised and really energised us in terms of that direction of travel. So those resources, that piece of practice guidance, that is accessible on our website in the Child Impact Assessment Framework. So even if you don't work for CAFCAS, but if you're curious, please do take a look at that. That's publicly available. And alongside that, we've kind of launched a comprehensive learning and development package to really help embed some of the principles and the expectations in that guidance. I'll sort of come back to that in a minute. But also we've launched the new CAFCAS practice framework, which is called Together with Children and Families. So this is a practice framework that isn't specific to children and families who've experienced domestic abuse, but it's a much broader practice framework that governs the way we do things around here. It's a set of principles and values. There are some tools and various elements to it. But it's a restorative, strength-based practice framework that I think kind of dovetails very nicely in terms of some of the work we are doing around domestic abuse. The third pillar of the plan is around really facilitating more opportunity for feedback. So there is a review of the CAFCAS complaints framework in progress at the minute. And we're doing some work internally to really ensure that lived experience, and when we do get that really rich feedback, whether that's feedback from people who've had a successful experience who are feeding back positives, or whether that's people who have had a more difficult journey through the family court, we're really trying to tighten up internally how we ensure that any learning from that then does filter down to the front line and is experienced and understood by our practitioners. And the final pillar, so the fourth pillar of the plan, is really around using CAFCAS's influence as a national organisation to influence the wider system, well, both locally and nationally. So we're heavily involved in a lot of the reform work that Jenny and Jack have mentioned earlier, and we're also trying to use CAFCAS data and insights to inform some of that system reform. So we're involved in work with the Nuffield Family Justice Observatory, some of the work that's happening with the MOJ. So trying to use some of the resources internally that are already there to kind of influence the wider system. So if I just go back to the second pillar there, because I expect that will be the thing that colleagues in the room today will be most interested in. So as I described, in order to really support frontline practitioners in this really, what can be a really challenging area of practice, we have launched an updated version of the CAFCAS domestic abuse practice pathway, and there's now a much richer, fuller practice guidance document that kind of sits alongside that. So do kind of have a read of those two documents together. And as I described, we've put in place what I hope is quite a comprehensive training programme or learning and development programme that should help embed the content of that practice guidance. So far we've had 948 frontline practice staff and managers who've attended the workshop element of that training. We've got another 430 odd booked on to go at the minute, which is a strong start. However, we do have, I think it's about 1,800 practice staff, so still quite a few people to get through, but a really strong start. So as I described, it is quite a comprehensive programme. It's not just a kind of one-off static piece of training. That's not going to be enough to shift the culture shift that we need to see in the family court. So alongside the workshops, there's expectations around reading, there are group supervisions, there will be the personal learning plans that I mentioned earlier, and just this month actually we've launched a webinar series as part of that programme as well. I'm really excited about the webinar series. We have brought in some external speakers. So the first session happened earlier this week, and that was hosted by Emily Allison, who's a consultant psychologist. We have a session coming up with David Mandel, who was founder of the Safe and Together programme in the US, and has done a lot of work kind of internationally. But it's also really important that as part of that webinar series, we've got a few more coming up into the winter, that really centres the voice of survivors and children and family with lived experience of the family court. We've also kind of ensured that we use video material and other kind of resources in the workshop element of the training that really kind of incorporates those survivor voices. And certainly from the feedback that we've had so far, that's the material that is kind of really connecting with practice staff. It's interesting, some elements of the training. So for example, we focus quite heavily on helping practitioners to delineate between what is harmful conflict and what is domestic abuse, because I think that was one of the messages that come out of the harm panel report. We sometimes see domestic abuse minimised or conflated with harmful conflict. Now, we tried to tackle this. We started addressing this, 2017, 2018, when we'd done some previous training. But I guess as an organisation, we'd focused on technically how do you delineate between the two. We'd introduced an evidence-informed practice tool to help people untangle these two very distinct sets of behaviours. But I think what we recognise now is that without having a conversation about the culture within the court, and without understanding what's the impact of that conflation, what's the impact of that on a child or a parent who's experienced domestic abuse, who's been systematically victimised, and then sees that reframed in the family court as being conflict or acrimony or something that they are somehow complicit in. It's those kinds of conversations and opportunity for reflection that I think will help shift practice, not just the kind of the technical aspects that we've perhaps focused on before. So that's kind of the learning and development programme in a nutshell, really. Like I said, lots of activity. We've got a lot of people through the programme so far, but still quite a lot to do. And just to add as well, the other two elements of the learning and improvement plan, where there's certainly still work to do, is around the improving access to our data for partners, and the complaints review as well. So do watch this space. There's lots of activity going on internally at CAFCAS at the minute, but like I described, from where I'm sitting, it certainly seems as though there is hopefully not a defensiveness and hopefully an appetite and energy to get it right for survivors.
Many thanks, Natalie, for that. I just wondered if all our panellists could just put their cameras and speakers back on, just in case there's any questions at all, and then we can go straight to you. So I'll go to my assistant, Keith, and I don't know if there's any questions from the hall, Keith.
Thank you, Nicola. I'm very aware we got close to your lunchtime, but I'm willing to take questions because I love to have the interaction. I've got one speaker here. Could you go to a microphone, please? And could you introduce yourself and tell the panel who your question is directed to, or if it's to all of them? Thank you.
Chair, conference, Nicola Kenny, Family Court Section. I've been around a long time, and we've moved a long way forward in looking at practice issues with domestic abuse. I'm really interested in knowing if Jack or other panel members have got any ideas about how we can collectively campaign. Yes, we look at the practice direction 12J and issues about fact finding, but the number of times we have section 7 orders for section 7 reports where there's a recital that says everybody agrees we don't need a fact find hearing. That's really difficult when the family court advisor digs deep and decides that we really do need a fact find. And also in preparation for fact find hearings, judges are so keen, because they're under terrible stress, to limit the number of allegations that they will consider. And again, it waters the picture down. The former president of the family division, Justice Mumby, 3 or 4 months ago on a TV programme said, the bottom line is there is a problem with training. And I think CAFCASS is well ahead of the game now, but lots of the judiciary, new recorders and magistrates courts are not. So any ideas about how we can collectively campaign to make other improvements?
Thank you. I'm aware of time. I don't know if there's any more questions from outside the room, so I'm going to go to the panel to answer.
I'm not sure who wants to go first. Does Jack, perhaps? You came into view. Thank you, Jack.
I think that's a really difficult question, because a lot of that will come down to professional confidence and professional assessment on a case-by-case basis. If you are directed to file a CAFCASS, a welfare report, a Section 7 report, with an order that recites that the judge doesn't think a finding of fact is necessary, and you as the professional appointed to represent or represent the views of the children and assess risk, disagree, then you must say. And if the judge doesn't like it, they get paid a lot of money to listen. So tough. But if you think that something has been missed, or that there is a genuine need to look at allegations or look at the circumstances of a relationship, and don't forget that, you know, one of the points from ReHN was that it isn't just about these reductive lists of allegations. It's about looking at the experience of being in a relationship that parent had, and what impact that has on them as a caregiver as well. Then you must say, and you must explain in your report why you take a contrary view, and any judge will take that seriously. So I think a lot of that comes down to confidence in being able to say, actually, I'm the professional, I've met the children, I've met the parents, and I disagree, and here's why.
Thank you, Jack. I think there probably was a question in there around support to family court advisors who might want to challenge what the family court does. And I suppose we heard a little bit from Natalie about that, but I don't know if you would want to comment any more on that, Natalie, about the support for FCAs who want to challenge what happens in the family courts. Thank you.
Yeah, I think Jack's absolutely right that tackling that does quite often come down to what I describe as a courage, a certain amount of courage that I think it requires and I think that's particularly challenging in private law, because you don't have the benefit of a lawyer, you don't have the benefit of a social worker involved with the child or that whole care team. You're kind of out there on your own. So I often speak to practitioners about, you know, don't worry about being difficult, don't worry about, you know, really kind of asserting your professional opinions confidently. That's what we're required to do. But you're absolutely right. It's important that the FCAs are supported internally and feel safe to bring that challenge to the court. So a lot of that support was happening organically. I know from my own experiences that I've been supported in the past when I've had to challenge a judge on a direction of travel or potentially a court order that was unsafe. The other one that we sometimes get, not only the sort of everybody agreeing there doesn't need to be fact finding, leaving us in a tricky position, but sometimes we will see that phrase, you know, the mother makes X, Y, and Z allegations, but she agrees it's not a bar to contact, as if there's this kind of arbitrary threshold at which contact should or should not be happening. So again, that can leave the family court advisor in a very tricky position if actually their risk assessment is that these concerns about domestic abuse are likely to cause harm. So whilst a lot of that all of our staff do have access to situational supervision at the point that they need it. But I think it's helpful now that we've firmed up that expectation a bit more. Now that kind of expectation that managers will help challenge potentially unsafe court orders. It features in our safeguarding policy now, so really kind of fundamental piece of policy in CAFCAS. And as I described it, it features very heavily in the manager workshops that we're doing as part of the learning and development programme as well.
Many thanks, Dustin. I don't know if Jenny wanted to pick up anything from that question at all. I'm not certain how far along the training for judges is going. I don't know if you've got any information about that, Jenny, or anything else you might want to contribute. Thank you.
Okay, thank you. Sorry, I'm not able to turn my video on again, but I'll start answering the question.
Thank you. We can hear you.
I think at Women's Aid, we're very aware of the culture in the family courts and just how difficult it can be to challenge a judge or a magistrate. And we know that that can be difficult for CAFCAS officers and for victims and survivors who are litigants in person. It can be absolutely terrifying. And so I think this is all part of what we would like to see about transforming the culture and transforming the system so that people aren't, sometimes survivors tell us that the culture in the family court seems to replicate the power dynamics of when they were in an abusive relationship. And that it's really hard to say what you truly feel. And, you know, we get all these statements, oh, mother has agreed to contact. But in most cases, she's terrified of not agreeing. She thinks if I agree to one Saturday a month, then at least it won't be more than one Saturday a month. So there are all these sort of power dynamics and pressures, I think, on everyone who's working in that space, and that's really why we would like to see that change in how things work. Around the training for judges, we have been promised that organisations from the domestic abuse sector will be able to have a meeting with the president of the family division to be briefed on this and to input into what they're planning going forward. So until we have that meeting, I don't really know what I can say about that yet.
Many thanks, Jenny. Oh, sorry, Keith.
I'm going to say I haven't seen any more indications, but there's none from outside the room. I don't think. Oh, I've got one, have we? One question. Oops. I've been frantically trying to keep with the message. If you wonder what I'm doing, my technology skills are somewhat limited. I have a question.
I think I have the question, Keith. Do you want me to ask it?
Thanks.
I've got a question from Sue Hassel, who's family court section. She asks, how are delays and resourcing impacting on implementation of the programme? I don't know if that's a question for Natalie, is that Sue? But if anyone else wants to contribute, then please do.
Yeah, I mean, as I described, you know, the backlog that's present in the court at the minute is inevitably having an impact in terms of the pace of change, I would say. I don't think, again, from where I'm sitting, I don't think it's having an impact in terms of people's appetite and sort of commitment to change. You know, I was perhaps expecting when we rolled out some of the workshop elements of the learning and improvement work that there might be a degree of pushback just because of the context that people are working with. That hasn't been my experience so far, and as far as I'm aware, that hasn't been the experience of my trainers. I guess in terms of how is that translating in terms of practice on the ground, time will tell. Like I said, we are in the process of repeating the 2020 audit, so we are in the process of repeating that. So that will tell us a bit more about the pace of change and what impact the the training material and other sort of shifts within CAFCAS that'll tell us a bit more, you know, about the pace of change. So it's a bit early for me to kind of comment on that at the minute. But what I can say is that it doesn't seem to have diminished people's desire to improve and strengthen their practice.
Many thanks, Natalie. I think we're going to have to bring things to a close now, unless anyone else had anything else to say from the panel. No one's indicating to me. So I just would like to thank you very much. And can we all please show our appreciation for the panel? This has been a really interesting session. So thank you very much.
Thanks, Nicola.